Can I ask you what he's doing on the stand? Because the trial to me has been going well for him. The prosecution's struggling to make its case. The witnesses like Richie McGinnis of the Daily Caller, who was an independent journalist there, testified about how the probably most contentious, shooting that took place was an attack on Kyle and really gave him grounds for self-defense, and on and on. Each one of the shootings, the defense has managed to get the foundation in for a directed verdict for self-defense finding. So why is he on the stand?
Yeah, the two areas of disagreement I had with the defense team was I believe that there needed to be extensive jury selection. They chose to go otherwise and pick a jury in less than a full day. And the other was I didn't think there was any necessity to put Kyle on the stand. I believe that the testimony would be as it has been, which proves every aspect of self-defense without the necessity of putting him on the stand. And particularly a young kid who's never been through this before, you're taking a lot of risks, putting him on the stand, subjecting him to cross-examination of a long-standing prosecutor. And the more innocent someone is, generally they struggle sometimes on the stand. It's Bill Clinton can lie very effectively. Your innocent kid can be telling the truth and people totally misunderstand it. And so that's why I was not in favor of him taking that risk. But hopefully it doesn't backfire on him, because the kid's as innocent as any human being I've ever had the privilege of defending.
There's the first guy who was shot, this Rosenbaum, who was a nutcase from the sound of it. And this guy was a convicted child molester. He was just out of the mental facility. He was running around looking for trouble. In a way, Kyle Rittenhouse wasn't even arguably. This guy was a troublemaker. And the testimony has all been that this guy threatened Kyle. He chased Kyle. The evidence just came out that he was hiding behind some sort of trash receptacle, like lying in wait. And then, I just don't think there's any chance of a murder conviction, intentional homicide on that guy. Then there's the second guy, Huber, who attacked Kyle with a skateboard. And, that too is deeply problematic because he was attacking him. Whatever was in Huber's mind about whether Kyle was a good guy or a bad guy, I don't know that it's going to matter. And then there was this extraordinary moment with this third witness who he shot but didn't kill. Kyle shot but didn't kill. Gage is his first name. And the defense got a Perry Mason moment with this guy on the stand yesterday, I think it was. Watch what happened.
When you were standing 3 to 5 feet from him with your arms up in the air, he never fired, right?
Correct.
It wasn't until you pointed your gun at him, advanced on him with your gun, now your hands down, pointed at him, that he fired, right?
Correct.
And there's the reaction shot of the prosecutor with his head in his hands. That's ball game on his count, is it not?
Agreed. Between Richie McGinnis's testimony that Rosenbaum yelled "F you" and then went for the gun and Kyle didn't shoot until then, Grosewitz's testimony that he was afraid Anthony Huber was going to kill him with that skateboard, then Grosewitz's own testimony that Kyle didn't shoot until he put up his gun and pointed it right at him. You couldn't have a cleaner, neater case of self-defense. And that's why he should be acquitted of all of those charges. And I didn't think it was necessary for him to take the stand, but hopefully the jury understands and sees him for the innocent kid that he is.
Right now, just an update from my team on what's happening inside the courtroom. The prosecutor's trying to link Kyle, his playing of the video game Call of Duty, to the shooting. He's asking about Kyle's same gun as the one in the video game, and the purpose of the game is to, quote, to shoot everyone. And Kyle's saying it's just a game. It's not real life. If this is what they've got, they're trying to paint him vigilante. You were going there enjoying, just the prospect of randomly shooting people, but the evidence doesn't support that. Then my team's telling me the judge is currently yelling at the prosecutor saying, quote, "I'm not sure what you're trying to do here." When the prosecutor asked Kyle why he chose to stay silent after the incident until now, the judge is saying that is part of the justice process. Kyle has no obligation to speak out. It's called the Fifth Amendment. What's going on? What's the story with this judge?
The judge is a no-nonsense judge, been on the bench almost half a century. That's why he intersperses stories between Romans and the Bible. And when he was at a judicial conference 30 years ago, old school judge. I call him a Southern judge who happens to be up in Wisconsin. He's a no-nonsense guy. And what the prosecutor just did is violate Kyle's Fifth Amendment rights. So basically, because you're not allowed to comment on a client or a defendant ever taking the fifth at any point in time. And just because he's waived it now and taken the stand, you still can't comment on him taking it previously. So what he just did is guarantee that if there is a conviction, it will be set aside because of the questioning the questioning that Binger just did.
Right, exactly. You're not allowed to do that. That's pretty steadfast. And the judge, well, maybe the judge just saved the case or a mistrial by saying, you got to stop that. That's not allowed. So what's the story with the jury? I haven't read much about them. What's the makeup and how do you think that plays in?
Well, one of the areas of disagreement between me and defense counsel was I thought as long as a jury was picked that presumed Kyle innocent, Kyle would definitely be acquitted. But that required, because of the extensive pretrial publicity, when we polled it, 2/3 of Kenosha jurors presumed Kyle guilty. So I thought it was very important to do a very probing jury selection and voir dire the way that took place in the McMichael Arbery case, which took 2 weeks in Georgia. Unfortunately, they took less than a day, so they kind of got at the end of the day, they'd wrapped and they'd already picked their jury. There's 18 jurors. 6 of them are alternates. We don't know which ones publicly are the 6 alternates. It represents Kenosha. Kenosha is a very blue collar town, an ethnic immigrant hodgepodge of, a substantial Italian, Polish. I know a Mexican American juror that's on there. And that generally represents and reflects the community. It's like a blue collar extension of Milwaukee and Chicago that sits right in between the two of them. And so a random jury was usually a mistrial jury or a split verdict jury in the polling data. So hopefully they got a better jury than that, but they'll probably need a little bit of luck because neither side put a lot of effort into jury selection that I could see.
No, that's cardinal rule in practicing law. You got to know as much as you possibly can about your jurors and how it might be likely to go for you. We've got the soundbite now of the judge coming down on the prosecutor. Let's listen.
Why would you think that made it okay for you, without any advance notice, to bring this matter before the jury? I was astonished when you began your examination by commenting on the defendant's post-arrest silence. That's basic law. It's been basic law in this country for 40 years, 50 years. I have no idea why you would do something like that. And it gives, I'll leave it at that.
Oh boy, that's not a good moment for the prosecution, Robert.
It's extreme misconduct. And this is a prosecutor that has misused and abused judicial proceedings to lie about Kyle all the time, in the name of trying to introduce evidence or argue bail when it had nothing to do with either. He was trying to inflame the court of public opinion with false news because he knew the local media could reproduce and reprint and republish anything he put in a court file with complete legal immunity from libel, even though it was libel. And he himself couldn't be sued because he put it in a court file. And he's been lying about this kid all the way through. He's been violating basic rights all the way through, but that is egregious. That's worthy of disbarment and suspension. You go up and comment on a person's Fifth Amendment rights in the beginning of a cross-examination in a way that every prosecutor has known, as the judge said, for 50 years not to do. He should be disbarred from the practice of law, and he definitely shouldn't be a prosecutor anymore.